Hey y'all, I am the loud little ducky, and Gingras has a problem. Can he solve it? Bar complaints to the Arizona State Bar for Mr. Gingras, internet attorney. Let's jump in. So this is Wednesday, August 7th, 2024 at 5:58 p.m. and it says, attached is my response to the charge from blank. As before, I have CC'd my client, Owens, on this response since the allegations relate to her case. Although Ms. Blank consent is not required here, per ER 1.64, she has nevertheless reviewed this response and has given her prior informed written consent to its contents. As I indicated in my other response sent earlier today, Ms. Owens is happy to discuss this matter with Bar Counsel and provide any additional information you/he may need. Blank's phone number is redacted, and she is also easy to reach via email, address CC'd here. Owens has read the charge from Blank and is familiar with both the complaint and the details in my response. Per ER 4.2, I don't believe Bar Counsel needs my consent to communicate directly with Owens. I assume such contact is otherwise authorized by law. If my consent is required, please accept this as my consent to communicate directly with Owens. This consent applies to both this charge and also 24 through 1826 Deans and any other matter involving my representation of Owens. Thanks, Gingras Esquire, Gingras Law Office, and his little picture that he has. And then we've got earlier, this is what Gingras is responding to. Good morning. Attached is a letter from the Senior Bar Counsel, James Lee, regarding the above referenced matter. Also attached is a protective order that was issued in this matter. Thank you, Jackie. And she is a lead legal secretary for the Arizona State Bar. So here we have email from the Arizona State Bar on August 7th, 2024. Dear Mr. Lee, this letter is in response to yours dated August 7th, 2024 regarding a complaint you received from blank. As explained below, the complaint has no basis whatsoever and it should be promptly dismissed. After reviewing the charge from blank, I need to be honest. Her allegations are largely, if not completely, unintelligible. I have no idea who this person is. I have never met blank, so I have no personal knowledge regarding her allegations except to the extent they are described in the charge you received. To help provide some context, as I explained in my response to the charge from Dr. Deans, I represented a woman named Owens with respect to a single case, Owens v. Eckerd. That matter involved a petition to establish paternity filed by Owens pro se on August 1st, 2023. In short, Owens claimed that she had a one-night stand with a man named Clayton Eckerd, who was formerly the star of a reality TV dating show, The Bachelor. In her petition, Owens claimed that she became pregnant with Mr. Eckerd's child or children. Why do you not know whether it is a one child or twins when she clearly stated twins? And she petitioned the court to establish paternity. Owens claimed she had a miscarriage in mid-October or early November 2023. But I thought it was July according to pictures. As a result, she filed a motion to dismiss the paternity action with prejudice on December 28, 2023. Confusingly, yes, all those statements before were confusing. Confusingly, the Superior Court granted the motion to dismiss, but then allowed the case to proceed to trial on June 10, 2024. The trial was supposedly focused on Clayton's request for sanctions based on his allegations that Owens faked being pregnant. Obviously, Owens strenuously denies that she ever faked being pregnant. Of course she does. I appeared in Owens' paternity case on March 25, 2024. Prior to this, I had no involvement of any kind in the dispute. Also, Laura was represented by other counsel in the paternity case for part of December 2023 through mid-March 2024. Importantly, Owens also had a separate matter involving Mr. Eckard, and then they've got the case number. The other matter was not a paternity case. This other proceeding involved a pro se petition for an order of protection, also known as an OOP. In short, the OOP case, Owens claimed Clayton harassed her by posting an embarrassing partially nude, give me a break, a sports bra and some yoga pants. That is not partially nude. Nothing disgusting as far as those areas that are seen on OFANs. It was out. So that is a lie. Photo on her on the internet. It was the Halloween costume with her fake sonogram, which we believe she stole from her sister. After a hearing in late 2023, at which Laura was represented by other counsel, not me, the court found in her favor and granted the protective order against Clayton. After the order of protection case ended on March 26, 2024, Clayton's attorney filed a motion in the order of protection case requesting relief from the order based on fraud. In short, Clayton's attorney claimed that Laura was never pregnant and thus ineligible for a protective order, which generally requires a prior parental or romantic relationship between the parties. To help respond to that issue, I entered my appearance in the order of protection case on April 9, 2024. However, the OOP case was later consolidated with the paternity case, so I filed nothing further in the OOP case after my initial appearance. That is true. She has the right to request one. But just because she has the right to request one, because they had sexual relations, just not intercourse, doesn't mean that the rest of how she got it wasn't fraudulent. Turning to that specific claim in blank complaint, she appears primarily focused on paternity case between Laura and Clayton. Based on her language, it is clear she is a member of the JFC cult, which I previously described. Her complaint is essentially nothing but copy and paste list of the JFC cult talking points, which have been shared online by other cult members. In case this isn't obvious, the JFC cult sees me as a threat to their goal of obtaining justice for Clayton. You're not a threat, you're an embarrassment to the law. So these complaints are presented solely for the purpose of harassing me and trying to interfere with my representation of Laura. We wouldn't mind Laura have representation, just not scummy representation. Because she doesn't, as much as we may not like her, she deserves somebody that is honest and truthful and is going to represent her best interest. And that's not what you're doing. Having said that, to the extent I can understand Blank's claims, here is my response to each point. Number 1, releasing stilled documents. Quote. Blank makes several references suggesting I somehow violated a court order by publishing sealed or confidential information. Here are a few examples quoted from her charge, all of which are completely conclusory and unsupported. Violating the rules of releasing sealed documents without court permission. Releasing sealed documents without court permission. Breaching confidentiality and contempt of court by unauthorized release of sealed documents. Instances of releasing sealed photos, medical records, and videos on social media. A video depicting Clayton Eckard's deposition, which was sealed in the Owens v. Eckard case, was allegedly made public before the trial scheduled for June 10, 2024, emphasis added. As I previously explained, in response to the charge from Dr. Deans, there is no court order sealing anything or otherwise preventing the disclosure of pleadings, transcripts, depositions, or records filed in the case. This is a popular JFC talking point, but it is also completely false. On the contrary, and I was previously explained, while Laura was representing herself pro se, she filed a motion on September 14th, 2023, asking the court to seal the entire record. That request was denied by minute entry order dated October 18th, 2023. After Owens retained counsel, the one before me, her attorney re-raised the same privacy arguments in the motion entitled Motion for Confidentiality and Preliminary Protective Order, which we posted right before this video, filed on January 17th, 2024. A copy of this motion is attached as Exhibit A. That motion expressly asked for an order allowing depositions and other discovery-related materials to be marked confidential and protected from public disclosure. And so he's got a snippet here, petitioner's proposed protective order, and then he's got that any party depositions in this matter, if deemed appropriate by the court, are designated as confidential. On February 15th, the court issued an order denying this request in its entirety. A copy of that order is attached as Exhibit B. And this is the court has received petitioner's motion for confidentiality and preliminary protective order. Order is denied. Petitioner's motion for confidentiality and preliminary protective order. So that was done. And we have gone over that. Aside from two separate motions filed by Owens asking the court to seal the record and allow parties to keep discovery materials confidential, both of which were denied, Clayton never asked the court for similar relief. He never moved for, nor did the court grant ever, any restricting the publication of depositions or any other case-related documents. There simply is nothing in the docket that would even remotely support such a conclusion. Bearing in mind, even if such an order existed, which it does not, the Arizona Supreme Court has previously determined a trial court cannot lawfully prohibit the publication of matters occurring in open court. Any such order is void. See Phoenix Newspaper Incorporated versus Superior Court. That is an Arizona case from 1966. Order prohibiting disclosure of details of court hearing violated Arizona Constitution and was void. Superior Court has no authority to foreclose the right of the people and the press from freely discussing and printing the proceedings held in open court. This probably explains why the trial court repeatedly denied Owens' request for confidentiality, privacy, and why the court specifically rejected her request to keep deposition transcripts confidential. And this is where that video where the judge says, I don't want anything medical related to be released by any party. They can only be released between the two parties. Now, that's not in writing, so I don't know if that technically counts because it wasn't put in writing. Also, and she said for like any reason or anything like that, but did that mean that Clayton could put out his own stuff if he wanted to? Not that any of his stuff medical stuff was needed in this case, but does that mean that Owens could put out her own? It was just that Clayton couldn't. So those are questions that need to be answered. And will the State Bar know about that video clip or that hearing that happened where the judge did say that? Or is it the fact that it's not in writing, it doesn't matter? And I don't like to be on Gingras' side, but that is what needs to be answered, and it's going to be answered by the State Bar, maybe, or we're still just not going to have answers on it. Most people have their beliefs in what that means, but does it mean that since it's not in writing, that it's null and void? And it is weird for that stuff to be kept private. But certain things can be kept private. It's very weird because this is family court and things like that. It's a weird scenario, and it would be interesting to hear from Judge Mata herself on what she meant by that. So moving on. In fairness, there is a single sentence buried in a minute entry order issued in February 2024, before I appeared in the case. Yes, because everything is blamed on the fact that he wasn't on the case then, which seems to reflect some sort of informal agreement between the parties not to publish medical records disclosed by the other party. But in this instance, Clayton never disclosed any medical records of any kind. No, he didn't. Never did he. Before you were on the case, after you were on the case, nothing. Everything that Clayton put out there, she put out there herself first on Reddit, in a Dropbox, or sent to the media. The only medical records at issue in the case belonged to Owens, and she chose to publish them to respond to false statements made by the JFC cult, Clayton and or his lawyers. Number 2, witness tampering. Threatening to have witnesses arrested. This is another popular JFC cult talking point. Now, something I want to address on here, I posted it as a comment on Twitter or X earlier this week. Is it really a good idea when you have already been told to watch your words due to professionalism, and you have these new bar complaints about your behavior, and in defending your bar complaints, you are continually calling supporters of Clayton a cult? Like, is that a smart move? To me, it doesn't seem like it. I would be like, if you could please stop doing that, that's not professional. Like, the fact that you're calling somebody who disagrees with you and your client a cult is not acceptable behavior. But we'll see where that goes. That is just my opinion, and I'm a nobody. But apparently, we claim I committed witness tampering because I threatened to have a witness arrested. Here is what actually happened. During the course of discovery, Clayton disclosed that he intended to call a trial witness named Mike Maraschini. Mr. Maraschini is an ex-boyfriend of Owens who resides in San Francisco. Owens dated Maraschini for approximately 2 years in 2016 through 2017. Maybe some of 2018, because I think Laura tries to say that, but, you know, Owens lies. The entirety of Clayton's disclosures regarding Mr. Maraschini are shown here. And then it's got Maraschini, Randy Sue Pollock, the attorney at law, and then it's got redactions. This witness is expected to testify about his prior interactions with petitioner, her alleged 2 pregnancies during the relationship, and the subsequent litigation. Seems pretty cut and dry to me. As I would in any case, while preparing the case for trial, I reached out to the contact person listed for Mr. Maraschini, a lawyer named Randy Sue Pollock, to ask if I could interview Mr. Maraschini to learn more about the expected testimony. After speaking with Ms. Pollock, she told me she had never heard of Owens v. Eckerd, and that she did not believe Mr. Maraschini would appear at trial. I asked Ms. Pollock to confirm this to me in writing. On April 19th, 2024, she did, in the email shown below. And then it says, you know, Mr. Gingras, Owens trial, Friday, April 19th, from Randy Sue Pollock. My client will not be testifying. That's great, but that doesn't mean that his old lawyer is his new lawyer. or a lawyer for one case may not be the lawyer for this case. I get that that is who everybody thought would be his lawyer, and all of this stuff would be okay, right? That you did all of this. But the problem is that Mr. Maraschini reached out to you personally about going there, what he was going to be saying at trial, and everything else. But you still went about it a sleazy, slimy way. But you failed to mention that Maraschini reached out to you personally. I get not wanting to talk to somebody that's represented. You can't do that without permission, but Maraschini himself gave you permission to talk to him. You chose not to because you had nothing to say to him. You wanted him not around because he was a bigger threat than Gillespie. Because he had the forensic evidence about the medical stuff and the doctoring of things that make your client look very crappy. Gillespie didn't have that. So you didn't call on Gillespie. You could have, you didn't. So why was Gillespie not as big of a threat? Then you have Clayton, but you can't call the police on him for the exact same thing that you did to Maraschini because he's a party opponent. So why did you just call on Maraschini and not both? I think it's because Maraschini was a bigger threat to your case than Gillespie. Continuing on, a few weeks later, just days before the disclosure/discovery cutoff, great, I'm glad you're finally saying it was before the cutoff. Clayton's counsel informed me that, in fact, contrary to Ms. Pollock's written representation to me, Mr. Maraschini would appear and testify at trial. Well, maybe Maraschini talked to his attorney after you had contacted her. Maybe Randy Sue Pollock contacted Maraschini and was like, what is this about? And maybe Maraschini got some advice from her. But at the time when you contacted her, she didn't know. In response, I explained there were several problems with this. First, Clayton had failed to disclose anything about the expected substance of Mr. Maraschini's testimony. This is where you forgot to put in there that you had an email from Mr. Maraschini directly. And that you didn't do this nonsense to another witness that was subpoenaed. In the same scenario, basically. They were both exes of your client. But you decided this one. Is that because Gillespie's is in that court, and so that court can choose to do that? And the fact that Maraschini's was out of state, you had a better chance with his? There are many scheming and sliminess things that are going on with this. And it could be for multiple reasons, but you won't ever be truthful about it. You say it's because your client was scared, when we all know that's not true. Second, I noted Owens had a current valid domestic violence restraining order, a DVRO, issued against Mr. Maraschini by the San Francisco County Superior Court, and that this order did not contain any exception for in-person testimony. Third, I explained that under federal law, the Violence Against Women Act, or VAWA, it would be a serious federal crime for Mr. Maraschini to engage in interstate travel for the purpose of violating a DVRO. Well, he didn't travel for the purpose of violating it. He traveled for the purpose of being subpoenaed as a witness in court. So that's a little untruthful. And I hope the bar sees right through your lies. Like, Mr. Gingras, you really thought that this was appropriate? Like, you do know that they are allowed to come testify, and that's not violating the court order. You know those are the laws, but you did this. Like, it's disgusting, and I hope you get hammered for it. All we wanted you to be, Gingras, was ethical. And you came and blew everything up and made things so much worse for your client. And then so they've got codes. Fourth, I explained that California DVRO could not be modified or ignored by the Arizona courts. VAWA expressly required the Arizona court to enforce the California DVRO as written, requiring a full faith and credit to be given to the Interstate Protective Order available at. But you forgot some other things in which Arizona says that you are allowed to come testify if you are under subpoena, even if they have a DVRO against you. And I hope the Arizona Bar points you to that, because I think you know that. You just are conveniently leaving it out, hoping that nobody says anything. Despite raising those concerns, I told Mr. Woodnick I would be happy to work with him and obtain permission from the California court that issued the DVRO so that Mr. Maraschini could testify. I am currently also licensed to practice in California. The only condition was I asked Mr. Woodnick to comply with his disclosure obligations by providing me with information regarding Mr. Maraschini's anticipated trial testimony, which Mr. Woodnick was already required to provide pursuant to Rule 49 of the Rules of Family Law Procedure. Mr. Woodnick rejected that request, leaving us at an impasse. You were told the substance of his thing, of what his statements were going to be about. You were told by him. Your client also knew what it was about. And so, no, you were not at an impasse. You just weren't having your way, so you threw a little toddler tantrum. After I was unable to reach any agreement with Mr. Woodnick, I filed an emergency request for a hearing with the trial court so these issues could be discussed. That request was denied without explanation. Well, they don't have to give you an explanation. That can just happen. Not all rulings have an explanation with them. That is allowed to happen. In order to preserve the issues on June 3rd, 2024, I filed a pretrial statement attached as Exhibit C, in which these same issues were discussed. See pages 9 through 11. In the pretrial statements, I explained it would be a crime for Mr. Maraschini to violate the California DVRO, and that any violation of the order would subject him to arrest. You also said that you weren't going to do that. And so he puts a snippet. Accordingly, if Mr. Maraschini appears at trial without permission from the California court that issued the original order, he will be committing a crime and will be subjected to arrest pursuant to ARS 13-3602. Yeah, and he never was arrested. So I guess he wasn't subject to be arrested, subject to having the police called on him by you and your client, but he wasn't subject to arrest. This issue has been reported to the court security by undersigned counsel, who was requested that Mr. Maraschini be arrested if he violates the DVRO as law requires. Yeah, well, that didn't happen. Court security knew about all this stuff. Like, they were fully aware of everything that was going on. There is absolutely nothing unethical or inappropriate about any part of these remarks. As the California DVRO under order attached as Exhibit D states, the order complies with VAWA and is subject to automatic mandatory enforcement in all 50 states. You tell that to what the hells in Florida when they do not want to enforce the Ohio restraining order. Not all judges do it. And sometimes there's a reason for not doing it. The order further contains exactly the same warning that blank points to as alleged witness tampering. Yeah, you wanted him gone so he couldn't testify. That was what you were doing. Your intention was not to keep your client safe. Y'all didn't want him there, and Owens was freaking out. And you're falling for her BS. Or you knew she wasn't scared, but you were willing to use it to try to get this happen because Maraschini testifying, although your case was bad anyways, and you lost without him testifying, but you knew if he testified with the forensic evidence and stuff, your client would really be toast. It notes Mr. Maraschini is subject to arrest for any violation of the order and interstate travel for the purpose of violating the order, which may result in him being charged with a federal crime. Yes, if he was doing it for the purpose of violating the order, but that's not what he was doing. And he stayed away from your client. He went to court, as he was subpoenaed to do, and still had nothing to do with your client. Clearly, there is nothing improper about me providing the same warning to Mr. Maraschini or his counsel that the DVRO itself contains. Yes, but you have the purpose all wrong. Number 3, posted a video of his client lifting her dress above her boobs. This one was interesting to me because, yeah, it just was. Blank charge contains several vague comments about information I posted about this case, including certain identified photos/videos. Blank claims one such video purportedly shows his client, Owens, in a manner that may be deemed inappropriate for public disclosure. See further explains. Gingras posted a video of his client lifting up her dress above her boobs, showing her in a blue bra and black panty lines. So that would make her partially nude, according to Gingras, right? What on earth is blank talking about? And why on earth would any sane lawyer post a video of his client lifting her dress above her boobs? But you did, didn't you? I never looked at it this way. But it's kind of funny that it was put this way. This one may be a little preposterous, but, you know, he thinks what the video was nothing worse than the Halloween costume photo that Gingras claims she's partially nude in and that shouldn't be posted on the internet, that y'all say Clayton did, but didn't. But you're going to put up a picture that's very much similar. Don't agree with your wording, but you're the one who said it. Here's why. Because on January 3rd, 2024, Clayton's counsel, Mr. Woodnick, filed a motion for sanctions in a paternity case. In that pleading, which he later withdrew, but not before the JFC cult seized on it, Mr. Woodnick accused Owens of appearing in court wearing a fake moon bump to falsely make it appear she was pregnant. I don't think Woodnick is the one that started those claims. I think the JFC people saw it for themselves. I know I did. Way before it was pointed out in a filing. I hadn't even read a filing before then, before I saw that video. Mr. Woodnick claimed that this happened during a videotaped court appearance that took place on November 2nd, 2023. Again, before I was Laura's counsel. Yes, that is an astonishing allegation to make, but Mr. Woodnick made it, as shown below. To save space, the entire 18-page motion for sanction is not attached as an exhibit. During the proceedings on November 2nd, 2023, petitioner wore a fake stomach, quote-unquote, moon bump to appear pregnant. Yeah, we believe that. And claimed with no scientific support that she was 24 weeks pregnant with respondent's twins due on February 14th, 2024. She's more than 5 months pregnant. And what's funny is this picture that she supposedly took after court that day or before court that day or whenever she took it is not a 5-month, 24-week pregnant woman with twins. Maybe you could be 5 months pregnant and look like that with one baby, not with twins. But oh, it wasn't growing properly, so that's why it wasn't as big as it should have been. But it's funny because that moon bump was huge. But your belly is oh so tiny in it. So it's not us coming up with false things. It's your client did these things. As it turns out, Mr. Woodnick's moon bump story was completely false. No, it wasn't. And you're an idiot if you think it is. I will insert that clip into this video too, so we can make sure that we see this bump and what it does. And tell me if it's completely false. Was it a real belly or was it a fake belly? I'm under the impression that it's a fake belly. But if you haven't seen this clip, you will be able to see it. He simply lied to the court about this point in an effort to make Owens appear crazy. Only a crazy person would wear a fake pregnancy belly in court. You're right, only a crazy person would, and your client is that crazy person. I would have reported this false statement by Mr. Woodnick to the State Bar as a clear violation of ER 3.3A1, but I understand the bar has an unwritten policy against considering complaints filed by lawyers in pending litigation. He has every right to think that that is actually what happened. But we'll insert it in here in case anybody wants to be like, oh, they said this, oh, they reported on this. These are the things that make us think that Owens is a liar. It's not just because we're just making it all up and everybody's so in love with Clayton. That's not what we have going here. If Clayton was the bad guy in this scenario, everybody would be against him. But that is not the case here. In any case, this cruel gambit unfortunately worked exactly as Mr. Woodnick intended. The JFC cult seized on the story and repeatedly spread Mr. Woodnick's moon bump claim far and wide. No, it was being spread before Woodnick mentioned it in his filings. We were just glad to see that Woodnick saw what we saw. An anonymous cult member even created a new Twitter account mocking Owens, showing a photo of her crying while being dragged away by police and suggesting lock her up. And so he's got the thing. Okay, great. Well, she is being referred for prosecution now, right? We think she should be locked up for all her scheming she's done for the last decade. Judge Mata thinks maybe she should be locked up. That's why she forwarded over a copy and was like, here you go, Attorney General. Or the DA. Also note that Moonbump Twitter account has tweeted 980 times about this case. Okay, who cares? They can do that. They're allowed to do that. And what they're doing, nothing is a lie. She should be locked up. And this person, whether that is what everybody thought or not, this person has the right to think that. It's what America's all about, right? Opinions, freedom of speech. Okay, so here is the bouncing belly. Sorry, I just clipped this off of a YouTube video to put it in here because I don't have it singularly anymore for some reason. I don't know what happened to it. But let me know what you think. Is it a lie that Woodnick and the JFC so-called cult made up? Or is it actually the truth and Owens is a lie? Is this a moon bump?
Her adjusting her bra.
Or is it a real belly? Swollen belly, pregnant belly, whatever. And does it look like a picture
You need to see
in comparison to size? Let's play it and see.
Alright, let's follow the bouncing belly. Here we got her adjusting her bra. Let's fix the hair. And boop. There it goes. You need to
You tell me. As the old saying goes, a lie can travel halfway around the world while the truth is still putting on its shoes. No, that is not what happened here. You may think that's what happened here, but a lie didn't go halfway around the world while the truth was putting on its shoes. The truth went around the world while the liar was acting like she couldn't put on her shoes because she was pregnant. That's what happened here. Even though you say in this instance that's exactly what happened, no, my incident is what happened. Always having to argue with Gingras. Jeez, he needs to quit arguing with me. After Owens hired me, and after suffering months of damage caused by Mr. Woodnick's cruel and patently false moon bump story being spread online, Owens asked me to help stop the damage. To do this, Owens asked me to publish a video she took of herself 24 hours after the appearance in which she allegedly wore a fake belly. How do you know it was 24 hours? How do you know she didn't change the date on the video? No metadata proving that. The video clearly showed any allegation of her wearing a moon belly was completely false, because of her swollen belly was clearly real. Why do you call it a swollen belly? This irritates me about as much as the banner health. Because that is not what it is. When I was listening to this being read by Tilted Lawyer, and he was still referring to it as the swollen belly, I was out shopping and I said to my mother, "Wow, look at that girl and her swollen belly. That's a pretty swollen belly, don't you think?" No, she's pregnant. It's not it is swollen, but nobody refers to it as that because it's crazy sounding. But I guess technically you can't be lying because you didn't call it a pregnancy belly. By just saying it's swollen, you're not technically lying on behalf of your client. And is that because you can't claim she was actually pregnant? Because you know, in fact, she wasn't pregnant? And you can't knowingly lie to the court? Why do you call it a swollen belly, Gingras? The tweet where this video was posted is shown here. And it was a tweet that said, Step 1, invent crazy lie. She wore a fake moon bump in court. Step 2, spread lie as widely as possible. Step 3, get paid for clicks and views. Step 4, people accept lie as fact. No, that's not what happened here. We saw it with our own eyes, you dimwit. Don't believe your own eyes, people. I know what you saw, but don't believe it. Like you just saw the video of her pregnant belly in court that day. Did we just accept a lie as a fact, or is that in fact not a real pregnancy belly? Step 5, she videoed herself in the same outfit 24 hours later. Who do you believe now? Same outfit. Wasn't she wearing a dress in that one? This is some pants. And then, it says that he posted it on May 4th, 2024. Yeah, but you can see her underwear and everything. Well, she looks rough here, I'll tell you that. But that is not a 24-week, over 5-month pregnant with twins. That's not what that belly looks like. Again, this video was posted with Owen's written consent and at her request, so this is not an ER 1.6 issue. While this sort of thing may seem very strange in any other context, in this situation, I believed it was necessary and appropriate given the vast amount of false information previously published online by the JFC cult. With Mr. Woodnick's assistance and encouragement. Number 5, he arranged for excessive security detail, including a bomb squad, drug-sniffing dogs, and a police escort. And then he says, welcome to the crazy world of the JFC cult. I just don't think that the Arizona bar is going to like that you're calling people that. I see in her June 26, 2024 email, blank self-identifies as part of the JFC collective, inserting term. I have very little response to these specific allegations except to say, no, I did not arrange for the bomb squad to appear at trial on June 12th. Or 10th. I don't know why I said 12th. To my knowledge, no bomb squad personnel were present. If they were, it certainly had nothing to do with me. I have no idea what the drug-sniffing dog blank is referring to. If there were any dogs present at trial, I did not notice them. I certainly had nothing to do with bringing them there. I don't know if dogs or the bomb squad or FBI or anybody showed up when Gingras called the police for the courthouse. I have no idea if that's true or not. Somebody that maybe was there can let me know in the comments. Court security did provide an escort to and from court for myself and Laura. This was done at Owen's request because she had received death threats from the JFC cult members. I really hope that any of the people that are a part of Justice for Clayton, Maraschini, Gillespie, any of those, are not sending death threats. Because that is not what justice looks like. That is not okay, ever. No matter how much you dislike or like a person on the internet, it is never a good idea to do that. And I know it happens in other cases when it shouldn't, like it happened in Depp v. Heard. Nobody should be sending those to Amber Heard. Don't like her, don't like Owens. But don't do that. Now, some of those threats, it seems like she did on herself. And that nobody actually, made those threats. Like she created a profile that made them. But if there was even one, and they are doing it for justice for Clayton and any of the other guys, that's not justice, and you shouldn't behave like that. Don't take things real world like that. And because Mr. Maraschini threatened to violate, and actually did violate, the DVRO by appearing in court without permission. He means permission from California, not permission from this court in a subpoena. Number 6, he made an unwarranted 911 call during which he followed the witness and disclosed personal information to the operator. Which he did make an unwarranted 911 call. He says it's not. We think it is, and according to the law, even if you have a DVRO against somebody, you're allowed to go testify in court even if they're there. As explained above, Owens had and still has a valid lawful court order from the state of California, which required Mr. Maraschini to remain at least 300 feet away from her at all times without exception. On the morning of the trial, June 10th, Owens informed me that she saw Mr. Maraschini in the parking lot within 300 feet. She then asked me to contact law enforcement to ask them to enforce the DVRO. I initially contacted court security, but they advised they were unable to help. They specifically told me that the only option was to call 911 and ask Phoenix Police to enforce the court's order, which they were required by VAWA to do. In response to the instructions from the court security, I called 911 and reported this matter to law enforcement. And we are going to take a look in just a minute at what law enforcement's description of the incident was. Because we need to make sure that we are comparing Gingras's lies and stretching of the truth or omitting certain details. People know that just because he's saying all this doesn't mean you should question what you know. Because you're not crazy. All of this is just a line of BS. But I want you to have receipts and facts of what reality is, as opposed to what Gingras says is true. For whatever it is worth, Judge Mata's division specifically instructs all parties and counsel to call 911 if they believe that they are in danger of physical harm. Below is an excerpt of an email I received from Judge Mata's clerk on April 4th, 2024, which contains precisely that admonition. I don't know what that word is. I'm a dodo bird. While the court cannot provide legal advice or advice on which forms to file, the Superior Court website features a resource center law library where documents and guides can be found. Here, the Judicial Branch of Arizona in Maricopa County Law Library Resource Center. If a party, or an adult for that matter, believes that a child is being abused or neglected, they may call the Arizona Department of Child Safety hotline at 1-888-SOS-CHILD, 1-888-767-2445. And if a person believes that they or a child are in danger of physical harm or are a victim of a crime, local law enforcement or 911 should be contacted. Thank you, Judge Mata's division. Clearly, Owens had every right to ask law enforcement to enforce a facially valid court order. Court security and Judge Mata's division advised calling 911 was the proper recourse, so that is what I did. There was nothing improper about this. Maybe you could have called the non-emergency number because there was no emergency happening. Finally, I have no idea what Blank is talking about when she says that during the 911 call, I followed the witness and disclosed personal information to the operator. If the witness she is referring to is Mr. Maraschini, that allegation is simply false. I stayed with or near court security personnel during this entire call, and when Phoenix Police arrived, I provided them with a copy of the DVRO, and I explained the situation to them. I did not follow anyone, nor did I disclose personal information to anyone other than law enforcement. I assume the personal information Blank is referring to is Mr. Maraschini's date of birth, which is listed on the DVRO, and which Phoenix Police specifically asked me to provide them. This is where I'm going to be on his side. Like, that's not divulging personal information. Because, they do have access to all that on the restraining order. And, if they're trying to pull up something in the records, then they're going to want the person's name and their date of birth to make sure that, they're talking about the correct person and stuff like that. So the divulging personal information type thing, that's, That's a little stretch in complaining to the bar about. You know, you can just say he called 911 on this person, you know, and was talking to the police, and while he was trying to talk to 911, he was making sure he had maraschino in his eyesight the whole time. Like, that could have been said enough. It's still ridiculous that it even happened, but the whole divulging personal information, that to me was a stretch by whoever put this complaint in. In any event, I believe this responds to all specific allegations in blank's charge. If you believe I have missed something, I would appreciate it if you could let me know the specific allegation you feel needs to be addressed. I will be glad to update this response if there's something further you need to know. As always, feel free to contact me with questions. Yours truly, Gingras. And so the Exhibit A was the motion for confidentiality and preliminary protective order that Corey Keith filed, which we have already gone over and posted on another channel, or not another channel, another video. Exhibit B was the ruling denying Exhibit A's motion from Judge Mata. We went over that when we went over the protective order. And Exhibit C, Petitioner Owens' pretrial statements, which we have gone over that when that was happening. I will have the links in the description box to those two things, the videos where we discuss those. And let's move on to the next part of this bar complaint, because this is just basically part one in all of this. So Gingras submits 2 extra exhibits, and in this submitting, Exhibit A is snippets of Eckerd's deposition transcript. We will go over that. Exhibit B is Maraschini's restraining order in full from July 8th, 2018, not the renewal, because there is a renewal, but he's putting in the original one. We've already gone over that in the Maraschini case. I will link that video in the description box, as well as the other ones that we have talked about. So let's jump into parts of the deposition. All right, so we have Eckerd's February 2nd, 2024 partial transcripts. So answer no, question, and what happened afterwards? Clayton says, we went to sleep for about 3 or 4 hours. Corey Keith asks, and did you guys put your clothes back on? Clayton says no. So then he says, okay, and then what happened from there? Answer, we re-engaged about 3 or 4 hours in from the last time, and she performed oral again. And that point she performed oral. I finished. She went to the bathroom. I don't know what she ended up doing with the semen. Corey Keith asks, let me slow you down a little bit. You guys are sleeping. You woke up at some point. How does it transition into getting physical with each other again? Clayton says, start kissing again, fondling, and then she started performing oral. Kissing, fondling, were you guys cuddling in the bed still at this time? Mr. Woodnick objects. Foundation. Clayton says yes. Yes, we were, I guess, cuddling in close proximity. All right, Mr. Keith asks question, and was there any sort of like grinding on each other? Clayton says, she got on top of me at one point. Yes. Question, and can you explain what you mean with, I know this is sort of a difficult topic, but can you explain what Clayton says? I don't care at all. Like, he's like, just ask what you gotta ask so we can get this over with, because I've got nothing to hide. Just do what you need to do. So Corey Keith says, you mean with body position when you say she got on top? Clayton says, yeah, she got on top of me, and I was laying down like this, and she was straddled on top of me and making out. And I guess there was My P and her V were in close proximity, but there was absolutely no penetration at any single point. Nor there was absolutely nor would I have ever been possible for her to have gotten pregnant because 4 hours in between, semen does not survive that long. Okay, and how long were you guys kissing, her being on top of you? How long is that taking? Woodnick objects with foundation. Clayton says 15-20 minutes. Corey Keith asks, okay, and then it transitioned. I believe you said back into oral sex again? Clayton says correct. Then he was asked, and then you testified this time, I believe, a little bit differently. You testified that, I believe. Let's go to the next pages. So those were the highlighted parts of that. We skip from page 24 to page 37 of the deposition. Clayton says, and that was the other part of it. Question, in front of you, presumably? Clayton says, yes, although she would not pee in front of me, but yes. Question, understood. Did you purchase that pregnancy test? Clayton says, I did. Question, and answer, let's call it an HCG test because we know that she was never pregnant. That's what Clayton says. Well, on the box, did it indicate that it was a pregnancy test? Clayton says, sure, I guess that's what they market it as for people that are actually truthful and taking these tests and don't lie. So he's not giving up. Yes, they're usually to detect real pregnancies for truthful people. Question. Okay, so you purchased this pregnancy test. Did you tell my client prior to her arriving at your house that you were going to ask her to perform the pregnancy test? No. And when you showed her or asked her about the pregnancy test, what was her response? Clayton answers that she had already taken one and she brought one with her so that I could see it and she'd be happy to take the test as well. So this is why this part right here is why, like, when she's like, he just forced me to take a pregnancy test. Like, he didn't even tell me that he was going to want me to take a pregnancy test. Bitch, you came with your own test because you were going to show him. So this, oh my God, he forced me to take a pregnancy test. He just sprung it on me. He brought me under there under false pretenses to take a test. This is why, to me, it's BS. And then there is, I didn't feel like I saw anything in her pockets. Not to say she didn't have something pushed up inside of her. I didn't check that, but she wasn't carrying anything into the bathroom. Question, okay, and she did perform the pregnancy test. Did she show you the results? Winnick objects to foundation and form. Clayton said, yeah, I saw the test. Corey Keith then asks, and what were the results of the test? Mr. Woodnick says form and foundation for his objection. Answer, there was one line and one faint one. So there were two lines, one was more faint than the other. Clayton says yes. And at this point, did you believe that she was pregnant? Clayton says, I had a moment of disbelief, but yeah, at the moment I thought maybe she had actually successfully trapped me by inseminating herself. That was my belief. Yeah. Like, she found a way to make a pregnancy test positive. I don't think she found a way to actually put a baby in her because that never happened. Otherwise, she would have a real sonogram from somewhere. So Corey Keith says, so when you give her a chance, you're referring to, if I'm understanding correctly, you would give her a chance with regards to the two of you having a relationship. Clayton says, yes, it was a lie. I had no intention of dating her. So, did he do abortion coercion like Gillespie did? But I was going to just basically tell her what she wanted to hear to see if she would just go away. Nobody wants to be around her. They just want her to go away, and they will say what they have to. That is not against the law to make her go away. And to maybe quit scheming and find something better to do. Question: and what you mean by that is to see if she would move forward with an abortion? Is that correct? Clayton said, yeah. And was this after my client came over to your house and conducted a pregnancy test? Clayton says, yes. Blank, read the text message out loud, please. Clayton says he's reading this text message, and it says, quote, "This is the last time I will communicate with you on this matter. I would like for you to get an abortion if you are pregnant with my client, which I still don't believe, but it doesn't matter either way if you do not. That's your choice, and in the case it ends up being my child, I have decided that either you will take 100% custody of the child or it will be put up for adoption. I will not be raising it in any capacity," end quote. So Corey Keith asks, okay, is that accurate depiction of the text that you wrote to my client? Clayton says, yes, I texted that. Okay, and isn't it true that you actually doubled down on that? You sent her an email with, and we don't go any further. For some reason we skipped over to 25 again, and it says, Clayton went in her mouth, and what happened from there? He said, she went straight to the bathroom, and I went to sleep. Question, okay, you said there was no intercourse between you and Owens, correct? Clayton says, correct. Why wasn't there any intercourse between you and Miss Owens? Answer, because she said she didn't want to, so I said, okay, I respected that and didn't push it. Yeah, because not every guy is an ARPist. Even though your client wants to say everybody that has ever come near her is one. Question, during your podcast interview, you stated that, quote, your grinding occurred as we were leading up to the climax the second time, end quote. Do you recall making that statement? Clayton says, yes. Is that an accurate statement? He says, yes again. How much time lapsed between the end of grinding and you getting your dollies off? Answer, probably 5 minutes because, about 5 minutes. Question, okay, was this the only ever instance of physical or sexual contact between you and my client? And when I say that, I am not inferring that you guys had intercourse, basically. So that is the depositions that he included, which we have seen before, but it's just a reminder of what's been said. No lies detected from Clayton here. Then we have Thursday, August 8th, 2024. Before it was August 7th. So Gingras sends this to them. As a follow-up to yesterday's emails, I need to add a couple more supplemental comments regarding the charge from blank. After for shortly before, the timestamps on Twitter are not necessarily reliable. My response to you yesterday, blank posted information about her bar charge on Twitter. I did not know about this at the time I sent my response to you. I only learned about it yesterday evening. Screenshots of blank tweet are included below, and a link to her post is here. You should be able to see this without a Twitter account. And it's to Tramp Stamp Esquire. Note, this Twitter account, Tramp Stamp Lawyer, is a parody criticism account created by the JFC cult, which is focused on publishing negative information about me. Before you ask, I have no idea what the significance of the term tramp stamp usually refers to a tattoo on a woman's lower back. I do not have any tattoos, nor does Owens to my knowledge. In any event, I have never threatened whoever is behind this account. I am blocked from the following accounts, so I cannot see their tweets when using my normal Twitter account. You are so far up Megan Fox's butt that you know what that is referred to. You have probably seen the video where that term was created. You just look like somebody that would have one. Because you were calling them cockroaches and wanting to read their obituaries and wanting them to be homeless and all of that. The reason we know blank posted this is pretty simple. The tweet includes a copy of the bar letter to her dated yesterday. Although she redacted her name from the letter, she did not redact the file number. Obviously, I have no issue with blank or anyone else posting truthful statements and fair criticisms online, nor do I have any objection to them sharing matters of public record. That's how the law works, although this is slightly ironic given that blank asked the bar for a protective order to prevent me from retaliating against her. As I indicated in my letter yesterday, I have no idea who blank is. I have never communicated with her, nor have I ever threatened her in any way. The first time I saw her name was when you submitted her charge to me yesterday. Yeah, and it got posted out there. This leads to my second point. I am concerned blank may have misunderstood Mr. Lee's comments in his June 26, 2024 email to her. In that email, Mr. Lee advised blank correctly that the statements made to the bar are subject to absolute privilege. That statement is, of course, completely true, and I have no problem with this. However, any suggestion that blank is wholly immune from suit just because she also submitted a complaint to the bar is incomplete and potentially misleading. I am concerned the reference to immunity in Mr. Lee's email may have caused blank to believe incorrectly that she is absolutely immune from a suit for any public statement she makes on social media simply because she also made the same statements to the bar. And that is obviously not correct. A bar complaint does not grant the complainant carte blanche to publish defamatory statements elsewhere, such as on social media. She didn't post defamatory comments. Most of what she posted was true. There might have been some things that they're true necessarily, but weren't worth reporting. And the only thing I don't know about is the bomb squad and the sniffing dogs. But the part about the arrest and intimidating a witness and things that you say online and stuff that you posted, those are actually all true. So I don't know how those are defamatory. Now, if she's posted other things that are defamatory and that are not true, that's another thing. But what was submitted in the bar complaint, not really. Nothing that you could actually sue her for. Clearly, while I have no intention of suing her or anyone else, if blank posts false and defamatory statements about me on the internet, she would be subject to liability for defamation regardless of whether she also happened to make the same statements to the bar. Well, she made them thinking they were true, and she has reason to believe that they are true, and it wasn't done with malice. So I think it is very important she understand this, and I think it is clear she does not understand this. Yes, because you think everybody is stupid without a law license. As I explained in my letters from yesterday, it is also important for Mr. Lee and all bar staff to know that the JFC cult is extremely dangerous, and they should be treated as such. Oh my God. We're not dangerous. Like, really? Yeah, we're just all so dangerous. We should just be treated like other criminals that I'm not going to name because YouTube probably wouldn't like them. In addition to making false statements to you, which they believe they can do with impunity, they are huge fans of doxing anyone they dislike. They will typically publish every document they can find which supports their narrative or which appears to denigrate myself or Owens or anyone else they dislike. Well, if they're posting documents, that's putting out truth and public stuff. They're allowed to do that. Who are they doxing? They didn't dox Owens. She doxed herself when she put her stuff out there. And we're not putting out things that just support our narrative. We put out all of your filings, which is Owens' side of the story. You know what documents we don't all have? Or all the documents before that you came on the case that Woodnick filed. We don't have all of those. We don't have all of Clayton's side. But we have tons of Owens' side. We just don't agree with it. And me, for one, whatever. There is something out there that is not great for Gingras, or there's a couple of things out there. There are past allegations and a past charge about him. I'm not covering any of that. I'm not posting any of that because that to me does not matter about this. That has nothing to do with what is going on here. I wasn't even going to cover past cases that don't revolve around all this pregnancy stuff until those cases became relevant to these cases because of her lies against Maraschini. So now we have to go back and cover them because they are a part of this story and her lies to try to get restraining orders. But I'm not covering stuff that does not have stuff to do with this. So maybe other people are out there putting that on their social media and talking about it. I, for one, am not. Relating to this matter in an effort to make it appear falsely that I am guilty of some wrongdoing. For that reason, I would respectfully ask that Mr. Lee exercise caution in his future correspondence with blank. He should be aware that anything and everything sent to blank will be posted online by her, not me. At the very least, in future correspondence, Mr. Lee should also inform blank that Supreme Court Rule 48L does not provide immunity from claims arising from the publication of false and defamatory statements on social media or anywhere outside of the scope of what the rule protects. One final note, in my letters yesterday, I suggested it is likely the bar has received or will receive many additional complaints about me relating to Owens v. Eckerd case. I realize that statement probably sounds paranoid, but there was a very specific reason for that remark. One of the primary leaders of the JFC cult is a YouTube content creator named Dave Neal. Mr. Neal claims to be a journalist. He is not. Instead, Mr. Neal's primary source of income is posting self-created videos on YouTube. Mr. Neal is also friends with Mr. Eckerd, and he personally attended the trial on June 10th. Mr. Neal even set up a tent outside the courthouse where he live streamed for several hours before the trial. He live streamed everything. Over the last several months, Mr. Neal has published hundreds of hours of videos about Laura and me. And among other things, anytime a pleading is filed, Owens v. Eckerd, Mr. Neal will obtain a copy from the court and then sit and read the entire pleading word for word on his YouTube channel. Yeah, a lot of people have done that. So what? We're allowed to. Mr. Neal earns money based on the length of his videos and the number of views each video receives. So he has an incentive to post as much content as possible and to make it as inflammatory as possible. Well, I don't make a whole lot of money, or any money really, and I'm not trying to make anything as inflammatory or more inflammatory than it is. I'm just speaking what is said here. and my opinion. He literally posts new videos about Laura virtually every day, and sometimes more than once a day. This has slightly reduced since the trial in June. It wouldn't have happened if you wouldn't have come on the case and started a bunch of crap, Gingras. Like, there wouldn't be. We thought that things were going to be quiet. We weren't going to be getting any more filings. None of that. We got the, public statement from Gingras because Laura finally was deposed. And then you came on the case and everything exploded. So, yeah, none of that would have happened without you. Several months ago, Mr. Neal submitted a complaint to the bar about me. The complaint was later dismissed. Despite this, Mr. Neal made a video discussing his allegations against me. And he posted this video, which, in my view, encouraged other people like Blank to submit additional complaints. And then he links the YouTube video. Now, I don't know about Tramp Stamp Esquire as far as why they submitted a bar complaint. To me, you should not submit a bar complaint or leave a Google review or anything like that if you have not had any direct contact with that person. Whether they were a client, you have talked to them, and Megan Fox has talked to him, Dave Neal has talked to him, and then everybody that was involved in the legal case and witnesses and stuff like that. Those people that have actually had direct contact with him. Those people, to me, can do that. I've seen in other, like, lawyers and stuff online, people get butthurt about something a lawyer says online, and then somebody online tries to submit a bar complaint that has nothing to do with the law or anything like that. And so, should they be aware of things? Yes. But, they weren't personally affected by them. The people that were affected, they should be the ones that submit the complaints. Like Dr. Deans has a right to submit a bar complaint. He did something personally towards her in a legal matter. So, to me, most of everything that the Tramp Stamp lawyer put out there, it's good that the bar knows about it. And he had already been warned due to Dave Neal's complaint about his behavior, but yet he still is talking about a cult and a cult leader, which is not. We don't have a meeting of the minds and wear rosary beads or whatever cult members wear. Not that people that wear rosary beads are cult members, but those little, like, necklaces and, like, some weird things, maybe crowns, crosses, I don't know. But sometimes there's nothing that cult members wear and they're in a cult, but that's not us. Like, we don't have a religious leader or anything like that. So he submitted the YouTube link. Obviously, I recognize and respect my ethical duty to cooperate with any investigation you may perform. I have always complied with that duty and will continue to do so. At the same time, I want Mr. Lee to understand this is not a normal situation. The JFC cult has anywhere from 2,000 to 5,000 active members or more, and they are obviously obsessed with destroying Owens and anyone else who stands in the way of their goal. I don't see anybody going after anybody that stands in the way of their goal. Nobody went after Corey Keith. And he was on Laura's side. Nobody went after him. We felt bad for him. And we found out when he realized the truth, he got away. But nobody's out there bashing everybody that's on Owen's side. That's just not the way it is. You can try to spin it that way, but it isn't. This is why I would expect the bar to receive numerous additional complaints if you have not already. This is not an indication of misconduct on my part. It is simply an unfortunate reality of what happens when you are dealing with an angry cult. As always, I'm happy to discuss further if anyone has questions. Thanks. He just sits there and says cult, 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 cult. And it's just, to me, so unprofessional. It's not professional. It's not ethical. It's just ridiculous and an embarrassment to have you representing the Arizona State Bar, in my opinion. That is me, though. But I know that it takes a lot to get disbarred. And this won't get him disbarred, unfortunately. He puts in a picture of the video. I filed a bar complaint after conduct and it was dismissed. That's Dave Neal. And then, an image of him going over a legal document. Then here, he's not very happy with the thumbnail that we used today, but I like the picture. I think it's funny. If Gingras was an old man, and it's just funny, but it's lighthearted. I mean, it took a lot of artwork, but it's also just done by AI. And so the Tramp Stamp lawyer, or Tramp Stamp Esquire, and had posted, David Gingras is officially under investigation by the Arizona State Bar. This news comes shortly after we've learned that Laura Blank is currently under investigation by Maricopa County Attorney's Office. Justice will be served. Hashtag justice for all victims of Laura Owens. This was posted on August 7th, 2024. And it's got a copy of stuff we've already gone over. And then, showing that it is Tramp Stamp Esquire on Twitter is where this picture came from, which he submitted a link for. Okay, my bad. We didn't go over that document. I just said we went over. Okay, so this is the email when it says attached is the letter protective order that was issued in this matter. When we went over that at the beginning of this video, here is what it is. And so it says State Bar of Arizona, and respondent is David Gingras. Dear Blank, we received your correspondence regarding possible ethical improprieties by the above named lawyer. I will investigate your allegations. We have assigned a file number to this matter. Please use it on future communications with this office. I forwarded a copy of your correspondence to the lawyer with a request that a prompt written response be submitted. Absent unusual circumstances, I will send you a copy of the lawyer's response. An investigator may contact you for additional information and input. At the conclusion of the preliminary investigation, I will summarize the case and present it for review by all bar counsel. If after this review we determine that no ethical violation can be proven by clear and convincing evidence, we will dismiss this charge and notify you. You are entitled to appeal a bar counsel's dismissal decision. So we'll see what happens with this. It's not going to get him disbarred. I would like him to have some kind of consequence, but he's not going to lose his license over this, even though he just shouldn't be representing anybody because he's not a good lawyer. We will refer all recommendations other than dismissal or diversion to the Attorney Discipline Probable Cause Committee, who may issue one of the following orders: stay of the proceedings, admonish admonition, probation, diversion, or filing of a formal complaint. We will notify you in writing of our recommendation and provide you the opportunity to object in writing if you disagree. The rules of the Supreme Court of Arizona govern lawyer ethics and disciplinary procedure. The state bar is bound by those rules in deciding whether a lawyer has committed an ethical violation and whether the lawyer can be sanctioned for that violation. You, as a complainant, are not party to the disciplinary proceeding. The state bar does not represent you and cannot assist you in resolving ongoing legal problems. You should consult your own lawyer to advise you on the rights of your potential legal recourse against the lawyer. If you intend to pursue the lawyer in a civil or criminal proceedings, you should not delay because state bar proceedings are pending. If you wait, you may lose important legal rights. For example, if you believe you are entitled to recover money from the lawyer for damages you have suffered because of the lawyer's conduct and must pursue such claims through the courts. The rules of Arizona Supreme Court do not provide for recovery of malpractice, contract, or other civil damages in state bar proceedings. Accordingly, statutes of limitations applicable to such claims continue to run, and your claims may expire before the state bar proceedings are completed. So that's not really going to pertain to here, but that's just saying that the state bar could take a long ass time in deciding this. At this point, your charge is not open to the public. However, the state bar may confirm to anyone inquiring that we have received a charge against the above named lawyer and are investigating it. When the state bar completes its investigation and decides whether to pursue formal charges, then your submissions, the lawyer's submissions, and perhaps other documents in the file may become open to the public. Anything you send to the office becomes the property of the State Bar of Arizona and cannot be returned to you. If you request copies of documents not otherwise provided to you by the State Bar of Arizona, you will be required to pay a copy charge of 50 cents per page, payable in advance. If you want to keep copies of any documentation you provide to the State Bar of Arizona, you should make copies prior to sending the documents to us. That should be for anything, people. We're just going to give regular life advice here. If you're going to send documents to somebody, don't send the only copies you have. Always keep a copy for yourself. And don't think that they're going to give you the documents back. Keep the original if you can and send a copy out. If you have to give the original, at least keep a copy for yourself so that you're not without it in any type of thing, whether that's medical, legal, anything that you need to keep, tax related. Just don't send in your only copies. The state bar receives more than 2,000 charges against lawyers every year. We cannot thoroughly consider each one without your patience and full cooperation. Please await contact from me or our investigator before submitting additional information. Thank you for bringing this matter to the attention of the State Bar. We will carefully consider it and take appropriate action within the rules and procedures established by the Supreme Court of Arizona. Sincerely, James Lee, Senior Bar Counsel for the State Arizona Bar. Now, this was just funny to me. It is just at the end of emails, but I don't care about the beware of external email. But I like the think before you act. I like that line. Gingras should do this anytime he posts something or emails somebody, says words, anything that he does, he needs to think before he acts. So I just wanted to highlight that because Gingras needs to take that advice. That is it for this video. That is all that we have on the bar complaints for the state of Arizona. We do not have Samantha Deans because obviously she's not going to put hers out there. But this is now 3 that we know about. Megan Fox might have filed one as well, so that may be 4. But I haven't heard any response or anything to her. But if we talk about Dave Neal's, this one, and Samantha Dean's, that's 3 at least that have come out of this. And It has nothing to do with the fact that he is representing somebody that's a liar. It has to do with the way he has behaved himself. Laura has to answer for her behavior. Gingras needs to answer for his. Just because your client doesn't act right doesn't mean that you need to also not act right. But we are going to end with the quote of the day. Impulsive actions lead to trouble, and trouble could have unpleasant consequences. This is why we should think before we act. Gingras and Owens both need to not act on their impulses, because every time they do, it just brings trouble. And for Owens, it has brought unpleasant consequences finally. She's gone without consequences for 10 years. Now it's time she pays the price. So that is it for today. I will see you in the next one. Don't forget to like, subscribe, share this video. Comment down below what you think about all this. And I will see you later. Bye.